I'm going to go ahead and bring in my third guest for the show. Richard McIntyre is a litigation and bankruptcy attorney. He began his practice in Tampa, Florida back in 1992 after graduating from Carnegie Mellon University and the University of Pittsburgh's dual degree program, where he received his Master's of Business Administration from Carnegie Mellon University and his law degree from the University of Pittsburgh. Mr. McIntyre's litigation practice includes business, real estate, and consumer litigation. Richard, welcome to the show.
Thank you, Jamie.
So let's talk a little bit more about, what your firm does and what you specialize in.
Okay, so we have a general practice firm. We do a lot of different kinds of things. We have people that do real estate, personal injury, BP claims, bankruptcy, consumer, and commercial bankruptcy. We have regular litigation. Today, I think we're here to talk mostly about foreclosure defense. I know that's something that's in the continuum of what you do.
Right.
And so one of the things we do, we have two people. All they do is help people who are in foreclosure, who need to resolve their issue one way or another, whether it's getting rid of their house, getting some time to get back on their feet, figuring out a way to move out, get into some other place. There's two people that just do that. Sometimes that's followed by a consumer bankruptcy. We have people that just do the consumer bankruptcies. Sometimes it's followed by a regular commercial bankruptcy because they have other properties. Maybe they have a business that has issues. But for the typical consumer foreclosure defense, I think those are the issues you kind of wanted to talk about today.
Yeah, I mean, you see ads on the different billboards and on TV all the time about foreclosure defense. What can homeowners do, when they get that foreclosure notice, or obviously they know, that they're in, underwater? What are some of the things that they can do to protect themselves in the system?
Right, that's a good question. So there's several things I think you need to look at on the front end, several issues people need to think about before they make a decision on how they want to proceed. One of them is forgiveness of indebtedness income. If they have a second mortgage potentially that's going to get discharged, that's going to get wiped out, if they didn't use the money to buy their house, they may have forgiveness of indebtedness income, which is the same as regular ordinary income. They end up with a tax return, or they get a 1099 from the lender at some point in time, and they'll have to pay tax on that amount of money. Now, if you file consumer bankruptcy, it could be discharged to the bankruptcy. You wouldn't have forgiveness of indebtedness income because there's an exception. So that's one of the considerations. Do you want to have a short sale? Sometimes a short sale is a good idea. Sometimes a short sale is not such a great idea. Do you have equity in the property? Do you want to stay there? Do you want to move? Sometimes people, there's a perception that they get to stay in their house for longer and they don't pay for it, but they're terrified because their kids are in a school district they don't know what to do. They don't know when they're going to have to leave. And so there's a lot of considerations that you put into developing an approach to help a person figure out what they want to do.
And so realistically speaking, and people see that and they're obviously frightened, foreclosure defense. I mean, obviously they're picking up the phone wanting you to tell them how they're going to be able to stay in the home and everything's going to go away. Is that correct?
That's right. Sometimes they don't want to stay in the home. They don't want to a lot of times you'll see people don't want to put any more money into a house if they don't know how long they're going to be able to stay there. And they don't want to stay there necessarily for free. They want to resolve their problem. So sometimes what we'll do is we have two different people. One person will do the foreclosure defense to stop the litigation process, and another person in our firm does mortgage modifications. What they'll do is correspond with the lender. They'll collect the financial information. All of the lenders have different programs to help people stay in their homes. Sometimes they'll reduce the interest rate to almost nothing. Sometimes they'll do principal reductions. And what we've really found is when we started doing this, the banks were all saying, we will not do principal reductions. It's not going to happen. Forget about it. Since last several, 5 or 6 years, a lot of the banks are doing principal reductions. And if you get a low interest rate, sometimes you don't need a principal reduction because the low interest rate has the effect of reducing the principal down to a number that's manageable, or a payment that's manageable, and the people can stay in their home. If, on the other hand, that doesn't work out, it gives them time to find a place where they can go. And sometimes they'll provide cash for keys to assist the homeowner in getting to that place and getting move-in expenses and things like that.
Yeah, the principal reductions that you're speaking of, they became a major player in the game here after the 2012 settlement against the 5 major banks, being Chase, Wells Fargo, Citi, and I forget the other two off the top of my head, but the $25 billion settlement that came down as a result of the robo-signing mess that hit, the banks foreclosing on people. Not necessarily, I wouldn't say illegally, just improperly. They weren't, properly documenting, and they weren't verifying, actual signatures. So when the state attorney general was caught wind of that back in 2009, that turned this business on its head, and then, it really stalled a lot of the foreclosures that were going through the system. And, when the settlement back in 2012 was a $25 billion settlement, and one of the things that they have to do is give principal reductions to homeowners, and so that's why you're seeing that, be a play versus years ago.
Yeah, I agree with that. Frankly, I think it was a pretty good thing for the banks to have happened, too, because if you look at the market back when that happened, home values weren't quite as high as they are now. They've really gone up, and I think that's been a good thing for the banks. The process would have been stalled whether that settlement occurred either way, There were so many things that were going on during the market when the housing boom was occurring. The foreclosures were pretty easy to stall, but really that's not the end objective. It was getting to the point where the homeowner can get back on their feet and figure out a way to either stay or go with grace. And what that settlement did was it gave them the ability to do that.
Yeah, and that settlement really turned this business on its head. And I can remember when that came through, the inventory that was just kind of flowing through the pipeline in my business really stalled, and all the focus got put on David J. Stern's office out of Miami. He was controlling about 40 or 50% of the foreclosure cases, and he had tens of thousands of files, and his firm was basically at the center of the robo-signing mess, and they were basically they were outsourcing signing documents and verifying information without actually verifying it. He immediately got terminated by Fannie Mae as soon as this all came down, and he ended up his civil case against him just ended up, or his criminal case just ended up against him sometime last year. I talked about it on the air recently, but he basically lost all his assets, and I think he's doing some prison time as well. I can't remember specifically. Ever since he's been put out of the business, and now we see all kinds of different foreclosure attorneys representing these banks, and that was just another big change I noticed in the industry after that came down.
No, that's definitely true. There's still some other issues. One of them, statute of limitations. On some of the foreclosures, they were filed prematurely. It's a real issue because if they didn't give the proper notice, they have to go back to square one. And you see a lot of cases getting dismissed these days, and now the statute of limitations is gone. There's an issue before the Supreme Court now that they're going to decide on whether or not the banks can go and reforeclose or whether they can't. You have people out there now where they're in an interesting place because their foreclosure case has been dismissed, the statute of limitations is run, and the banks can't reinitiate a new foreclosure.
Yeah, but hold that thought. I want to take a quick break, but I want to touch more on that when we come back from the break. If you're just tuning in here, you're listening to the Jamie Meloni Real Estate Show here on 1250 WINS WH&Z, and coming back from the break, we'll be talking a little bit more with Richard McIntyre, attorney of McIntyre Thanasides, so please stay tuned.
You're listening to the Jamie Meloni Real Estate Show with local expert Jamie Meloni. Now, here's Jamie.
Welcome back, everybody, once again to the Jamie Meloni Real Estate Show here on 1250 WINS WHNZ. If you're finding my show on the air for the first time, I invite you to tune in here every Mondays at noon as my show aims to become your information source for the Tampa Bay real estate market. Off air, find me over at my website, tampabayradio.com, where you can find all of my latest listings and pre-listed properties, as well as prior shows of the Jamie Meloni Real Estate Show via the show info tab, again, over at tampabayradio.com. Currently talking with Richard McIntyre, attorney of McIntyre Thanasides, about foreclosure defense here in Florida. And before we headed into the break, we were talking about a Supreme Court case, and I'm not familiar with this one, so catch me up a little bit on this one, about whether or not banks can reforeclose after a foreclosure suit is thrown out. Tell me a little bit about this.
Right. So the setup is where you have a foreclosure that was filed years ago, more than, say, 5 years ago, and they didn't give the appropriate notice. The standard documents have a notice provision that they have to provide notice in writing before they foreclose. Mm-hmm. And there's a lot of cases out there where they found that the notice wasn't appropriately given. And so some judges will kick the case, some won't. If they dismiss the case, and now the statute of limitations, the statute of limitations for an action on a written instrument is 5 years. Mm-hmm. So if the debt's been accelerated, they haven't paid for more than 5 years, the case gets dismissed, the lender's in a difficult position because they've got this note, statute of limitations passed, what can they do? Mm-hmm. And what's going to be before the Supreme Court is whether or not the bank, which is in that situation where the case has been dismissed but more than 5 years has passed, can they reforeclose? Can they foreclose on payments that would be due in the future? What can they do to get out of that situation?
And the notice that you're talking about is just the Liz pendants, correct? Just
no, I'm sorry. I wasn't clear about that. It's a notice within the mortgage documents. Okay. It says that if you don't pay, before I foreclose, I'm going to send you a notice in writing that we're going to foreclose, and you have different rights and remedies. You can catch up. You can do things to avoid foreclosure. It's like, I think it's paragraph 22 of the standard documents. And what we found is in a lot of cases, the lender or the borrowers never got the notice. And so the argument before the court is you didn't give the notice, you didn't have a right to foreclose, the case should be dismissed. And that's happened quite a few times. And so the lenders, because of the passage of time, because some of these cases have been kicking around for a long, long time, the lenders are in a difficult spot because now the statute of limitations to sue on the notice passed. So what do? And that's what the Supreme Court, as my understanding, is going to be hearing in the next year or so.
So that's coming through in the next year. So this is a notice that's in mortgages where they have to give a notice even before the Liz pendants. That's the notice of legal action that's put on notice to the entire public. So this is a notice that they have to give borrowers prior to actually foreclosing. And so is that one of the foreclosure defenses that your firm looks into immediately then?
That's a primary one. Holder of the note is the party. It's interesting. Whenever you go through the trail of documents, you'll see a person will go to a closing and they'll sign with pick a mortgage company. It's a local mortgage company. The second they sign, the loan gets flipped to another entity. And back in the 2005, 2006 timeframes, it might have been flipped to 2 or 3 different entities. The entity that files suit, you look at the complaint, you'll see the plaintiff is this entity, and it's nowhere to be found in the documents. So the question is, why do you have the right? Why do you have what's called standing to file this foreclosure action? I can't find your name anywhere in the documents. Who's to say it's your claim?
Yeah, I see that in the business a lot. I mean, I tell people all the time that banks and investors trade these mortgages around like stocks and bonds. It's a financial instrument to them, just as a way a stock and a bond is to us. And that gets into these investors' hands, and they don't have all the documents they need, and so it muddies the waters. Would you not say?
No, I think that's exactly right. But I think really the upshot is to use it as a means to the end. And there's 2 things I think that are important. One, if you think about it, if all the banks that foreclosed had been able to move through the process as quickly as they had historically, there would have been a glut of houses on the market, which isn't good for the banks because it depresses the value. Someone wants to buy a house, the comps are going to be terrible, so they won't be able to finance the purchases. Really could have created an issue. What this process has sort of done, I think, inadvertently, is allowed a slow flow of properties to go back onto the market. So people in your situation, as you market properties for the banks and sell them, don't get inundated with properties creating horrible comps, because all you need is a couple bad comps and then it's hard to sell the house. They've allowed that stability in the market, I think, and maintaining the properties. You want someone in the house. If the house goes vacant, bad things happen. It's harder to sell the house.
And what is the timeline that you're seeing right now in your practice from the time a person receives the lis pendens to the time that they're actually the foreclosure or the final judgment? What are you seeing right now?
It's all over the board. It's at least a year. If you really do a decent job with foreclosure defense and the person wants to stay there and they go through the process of a loan modification, typically at least a year. And one of the things we want the homeowner to do is to start saving their money. Don't get used to not making a mortgage payment, because sooner or later they will be. We want them to pay the homeowners association fee, because it's really not fair for them to not shoulder part of the burden and have their neighbors shouldering the burden for the common area and maintenance expenses. But typically, at least a year, they can evaluate a bankruptcy down the road if that's something, if the lender won't give them a solution. And it's actually one of the things we look at. If you don't get anywhere with the lender when you're out of bankruptcy, you're dealing with a certain department within the foreclosing creditors' offices. A lot of times when we get to the end of that process, they'll go into a Chapter 13 or some form of a bankruptcy, because then a new department gets it. And sometimes that department is more receptive to cutting a deal. So sometimes we'll use a bankruptcy at the end of the model to get a deal worked out if you can't do it out of bankruptcy.
Now, speaking of bankruptcy, you hear a lot of times, I'll just file bankruptcy, they can't take my house. If it's a homesteaded property, is that 100% true? If you're bankrupt and you file bankruptcy, are you protected?
Bankruptcy is not exactly a magic bullet. They can't. It stops the process. There's a thing called an automatic stay that stops the foreclosure process. But the person has to start paying for their house. In fact, if you file a Chapter 13, one of the things you have to do immediately upon filing, you have to start making payments to the trustee. So it's actually interesting where you're out of bankruptcy, you could be going along for a year or two, not making mortgage payments. As soon as you file that 13, you have to start making the mortgage payments or your case will get dismissed. But it does give you the ability to restructure the debt. And a lot of times a significant thing is if there's no equity after the first mortgage, it gives you the opportunity to lien strip the second mortgage, which means take off the second as a lien. Now you only have a first mortgage on the property, and sometimes that right sizes the situation so that the person can move down the road. The second mortgage becomes the equivalent of a credit card debt, and you don't have forgiveness of indebtedness income. Okay. So it provides some benefits that way.
Okay, very interesting. And I think another important point that you touched on within foreclosure defense is people have to work with you, and they have to work with their lender, correct? You're talking about loan modifications, something I think a lot of people they want to sweep it under the rug and kind of forget about it. But you're saying if people are, diligent and working with you and the lender, they can probably expect about a year's timeline between when they're given notice and when they're actually, the foreclosure is finalized? Yeah,
we have people that have been in for 2-3 years, and we have people where, for whatever reason, it gets moved a little more quickly. But at the end of the day, if they're willing to work with the lender, I think more times than not, they can get a decent deal. But they have to be diligent. They have to provide financial information. Sometimes the lender will come back and say, we've taken a little too much time. We need you to resubmit the information. And while it's frustrating to the borrowers, I think the right process is you give them all the information you can. You keep the house up. You keep the house nice. You pay the HOA fees. And ultimately, there's a deal to be had there.
Okay, we've got a minute left, but I want to raise a quick question because I know it comes up all the time, is when people short sell their homes, when the mortgage is forgiven, what can lenders down the road come back on them and want to collect the debt from them?
Right. That's the other side of the coin, and I'm glad you raised that. So some people, they don't want to stay in their home. But at the same time, they worry about what happens when I go. One of the most important things is to get a release from the lender. If you don't get a release from the lender, you could be pursued subsequently for a deficiency. And one of the things when you see someone coming in for a short sale, one of the things I always tell my clients is make sure in your realtor's contract it provides that you don't have to sell the property unless they get a release for you. And if they get a release for you, that's a great thing, but you don't want to be obligated if they come in with an offer and you say, I'm not selling unless you get a release. They have a legal claim for the commission if you don't close unless you have that provision. The other thing is the forgiveness of debt. If you're not in bankruptcy, you could get nailed for forgiveness of debt even on a second mortgage. So you want to look at each situation and make sure that you're not teeing up a worse solution. If you think about a short sale, it benefits the person that buys the property and it benefits the broker. It doesn't always benefit the homeowner because now they got a non-dischargeable tax debt if they can't wait out the appropriate time in a bankruptcy.
Well, a lot of great information, Rich, and thank you very much for coming in studio today. Real quick, what's a website where people can find your firm at?
So our website is www.mcintyrefirm.com, and our phone number is 813-899-6059. Thank you for having me.
Yeah, thank you very much, Richard, for coming in studio. And again, you can find his information over at TampaBayRadio.com after the show. If you're just tuning in, you've been listening to the Jamie Meloni Real Estate Show, and I'll see you all back here next Monday at noon on 1250 Wins WHNZ.